benefit of the provisional filing is it gives you that 12-month window, so you can go off and talk to other people about the idea. You've now gotten the application in before making public disclosure. So you can investigate your market potential. You can get an attorney, legal counsel to help you out, or a patent agent. And you don't have to do all of the formalities. The patent term, once you get a patent, so if you file provisionally, you file it up with a non-provisional, or follow it up with a non-provisional, and then get granted a patent, the term of protection started from when you filed that provisional. So that's when you can put patent pending on something you're making, and eventually tell somebody, look, I've got a patent in progress on this. If they ignore you and the patent grants and you win, your lawsuit against them, then your damages go all the way back to the start.
Do I have to disclose that the patent is pending, or can I just
You don't have to write down patent pending on anything that you're selling, but as I said before, you have the responsibility to assert your rights to someone that you believe is infringing upon your idea. To file provisionally, oh, I'm sorry, yes. That is tricky, and the buzzword is it depends. So if you're nailing down the details of what it is after you've made the provisional filing, the question is the protection that you ask for needs to be rooted in what you wrote down in the provisional in order to get benefit of that provisional filing date. If something has happened in your field in between your provisional date and your non-provisional date, and you add that information into your non-provisional, now we have a tricky problem of trying to figure out who came first. Yes? No, the provisional is a filing in and of itself. You don't make amendments to a provisional.
So does that mean that you file multiple provisionals in that case, where you do have changes to the initial invention to get multiple priority dates?
I have examined applications that are based on multiple different provisionals. What becomes tricky for me as an examiner is figuring out what critical date to assign to a particular claim in the final non-provisional patent. And that's going to be me looking at which one of these more than one provisionals actually had all of the idea in it. Or, how many do I have to put together and what's the last date that matters out of that set? So it's been done. I've seen it done. It makes the possibility that somebody could come up with an idea a little riskier. Other questions? I should have brought I have a more extensive presentation on provisionals and non-provisionals.
But you said like you will never examine a provisional patent.
Yes.
So even if I just write a Shakespeare story, it doesn't matter because it's never going to be examined, right?
Yes.
So it's just a way to tell me that in 1 year I'm going to file a patent.
It is. You are writing down in enough detail the idea that you're going to ask for protection for in a year when you follow it up. So if you just write something that's totally unrelated, then that doesn't enable or support the actual idea that you're asking for protection for later on.
No, what I'm saying, what I understood that you will never examine a provisional patent, right? So you will never read a provisional patent, even during the whole patent.
That's not true, right?
That's, no.
You do it sometimes, right?
When I'm actually examining the non-provisional application, I am also looking at the provisional that was originally filed. So if you never file a non-provisional, then nobody ever looks at the provisional. But if you do file a non-provisional, then things you ask for in the claim, we will look at the provisional to see if it was fully described there in order to give you that extra benefit of a year.
Just to clarify again on
I think he was first.
If you file a provisional and let's say nothing comes through and you just let it lapse,
Mhm.
and then you just go ahead and using the same idea, you file another provisional, assuming no one else has done that, right? Could you still eventually get a patent?
If you file a provisional, let it lapse, file another provisional exactly the same, if nobody has come up with the idea in the interim, that's not a problem. If they have come up with an idea in the interim, then that's a problem. And then you had a question.
Yeah, just to clarify again, I think you already said it, but on the previous comment that I made, if I want to make updates to the idea, I would not, there's no way to actually make updates to a provisional. I would have to actually stack on multiple provisionals to get multiple priority dates. And then I can group them together to make a single patent filing.
You would, when you actually file your non-provisional patent, you would, in the paperwork, you would say, I am claiming, I'm trying to remember the word, but basically, I'm basing this on this provisional and that provisional and this other provisional.
So in the claims, I would say this claim is from this provisional, this claim is from that provisional?
No, that's not the way that you write claim language. So you just write the claims, and then it's up to the examiner to sort it out.
So I guess it's a counterintuitive because big companies are in the number game. They want more patents. If I have three provisional, I would like to have three patents. But if I'm going to combine them, I'm reducing the number of patents I have.
That's a strategy question. I'd like to move forward a little bit, please. Yeah. So, actually, as he said, it all comes down to what's the protection that you're looking for. What defines the boundary of your idea? What do you want to exclude other people from doing? And if it works out that you do 3 provisionals in order to create that scope, that's your decision and your business strategy. But I would like to move on. So non-provisional, as I've been talking about, needs to have a full written description of what the invention is, 1 or more claims that define the legal scope of the protection you're looking for, drawings if necessary to understand the invention, and even with software, flowcharts, please, or a description of the system that you're in. It requires an oath saying, I invented it, and then the fees that are required to actually file it. We have a guide at non-provisional patent on our website. Now, I've talked several times about the claims. So it's this English language description of what you're asking for. You can write something that's really specific. I have seen claims that run to 3 or 4 pages long describing the invention. That may very well be too specific to be economically useful. It's up to the inventor. If that's what you need to do to fully describe it, then go ahead. But be careful not to make it so specific that a competitor could make a small change and not actually be within the boundary of your idea. On the flip side, I've seen applicants come in with claims that are incredibly, they're huge. It's the property right equivalent of saying, I claim California. And then I'm saying, no, you can't have it. Obviously, other people are here already. So there's a sweet spot, someplace in the middle, not too big, not too small, Goldilocks zone. If anything, you want to err towards more general, and then that gives you some back and forth negotiation with the examiner as they find other work in your field. If you're too specific, also the examiner is probably going to say, yeah, here's a patent, and you could have asked for more. So there's the concept of big companies, small entities, and micro entities. A small entity is a company with 500 employees or fewer, or nonprofits, or individuals. And then micro entities are things that qualify as small entities, but have only filed at most 4 applications, and are within certain income thresholds, and are not going to turn around and assign this patent to a big company. The fees for filing are large entity, small, and micro. Currently, a micro entity is 1/5 of the costs of a large entity. So for a micro entity, it's $364 total to file a non-provisional patent application. At the end of the day, if we get to an actual patent, then there's an issuing fee. For a micro entity, it's $240. It goes up to $1,200 for a big company.
Is there a waiver on it for people who are low income?
That's one of the qualifications for micro entity, is to be low income. So this is the micro entity status is, as far as I know, the lowest cost that we have. So that's what I had to say about patents. There's a few resources I'd like to go over. Statistically, as I said before, there's 8,500 examiners, 13,000 people at the patent office total. In 2022, we had 646,000 patent applications come in, and we issued 361,000 patents. So, that's not the same set. Some of them were from applications from years previous. On the trademark side, 787,000 applications for a trademark came in, and there were 453,000 registrations. If you go up to the web page, and I can do a live demo if people would like to see, under free services, there's this quick link to either patents, trademarks, or how to find attorneys or business advisors. A new program that just came out for people that have not filed a patent ever, called the First Time Filer Expedited Examination Pilot Program. So the idea is to get people involved in the system. So if you've never had your name on a patent, if you've never filed for a patent before, you could qualify for this program. What this does is normally you file a patent application. It goes to, once it passes formalities and double checks and whatever, it goes into a queue and sits there for 12 to 18 months before an examiner picks it up and looks at it. This program lets you skip the queue. You go straight to an examiner.
Well, front of the line.
Yeah, okay. Yeah, front of the line.
Not necessarily originally picked up.
No, depends on the examiner. Ken, you might actually be surprised on that. Let's talk later. And it gives you, ideally, a much earlier response from the examiner, what's called an office action, and a much quicker idea of whether your idea is going to result in a patent.
Can I ask you a question on that?
Yes.
Right, is the idea on that, because first-time filers are going to be kind of inexperienced, and you just want to give them a chance to, that big one-year break would really be a problem if you're a first-time filer. Is that kind of the idea behind it?
I think that's the idea behind it. And in my understanding, the fundamental idea is to get more people involved.
But do I still have to face that high bar of your test? Or can I just get away with I have no experience filing patents.
The requirements for filing the patent and for it having support, adequately describing the idea is going to be the same if you're a first-time filer or if you're somebody that has 1,000 patents under their belt. The formalities don't change. What this program lets you do is get to the point of figuring out the formalities a lot faster. Mm-hmm.
So, while submitting the patent application, if I have multiple ideas and I'm looking to file multiple patents, but I'm still a first-time filer, one, does the application allow to submit multiple ideas as separate patents, or is it like for every patent I need to submit separate application as well? And how would that be treated, like if I was submitting four?
Okay, so you need to file one idea per application. The United States law says you're entitled to a patent. So we will, if we see an application come in that actually covers multiple ideas, the examiner will require with what's called a restriction, which says, okay, it looks like you have multiple ideas in here, pick one. And then later on, you can then pursue separate patents for the separate ideas, but you have to pick one to go first. For the first-time filer program, I don't know what happens if you file multiple applications all at the same time. It's a new program. I would have to refer you to somebody who knows the details.
And you said no additional cost, means like, or do I still have to pay?
You still pay the filing fees. So, as I said before, you could be eligible if you filed the utility patent. It doesn't apply to design or plant patents. You haven't been an inventor on a previous application, and you file it using our new patent center interface using DocX. And then you follow it up with a what's called a petition to make special, which gets you into the program. We have right now a total of 4 regional offices scattered around the country. I'm from the one here in Silicon Valley, downtown San Jose. There's going to be another one someplace in the southeast. If you want to, you can come to the office, or you can go and access any of the resources that I'm about to go through online. So we have a thing called the Inventors Assistance Center. That's a helpline that's staffed by people that used to be examiners or supervisors. They answer general questions, provide some answers to those questions, and then pointers of where to go to get more information. Certain lawyers participate in a pro bono program. They will provide services for free or low cost to people that satisfy certain income thresholds. That is on our webpage at Pro Bono Patents. The pro bono organization is by state. In all of the west coast of the United States is covered by California Lawyers for the Arts. They also provide help to people for other types of intellectual property as well. Did you get it? Yeah. Okay. There's different law schools around the country have what are called law school clinics, where second year or third year law students that are working on figuring out how to do intellectual property will draft patent applications under the guidance of their advisor or their professor. And you can get information about that at Law School Clinic. And then we have a whole network of resource centers around the country, the closest of which is the Dr. Martin Luther King Jr. Library downtown, actually walking distance from the patent office location in downtown San Jose. There's one in Sacramento and Riverside, LA, and where I was this morning, San Diego.
When should I go to the MLK library?
When?
When?
if you've got questions. So each of these centers has a librarian on staff that's trained in intellectual property issues. So you can ask them for some guidance. They can point you to resources that you can study to learn more about the process.
But to seek help in writing it.
So this is outside of this presentation, but if you're wanting to figure out how to write it yourself, actually, let me answer that after I finish this section. Because I only have 2 slides. We have many programs going on. There is in Sacramento tomorrow a patents boot camp that lasts all day. Every Thursday, we teach a class on how to get to a patent called Path to the Patent. So tomorrow I'll be talking about how to go about writing your provisional patent application. There's, similar to the patents boot camp, there's a trademarks boot camp, and there's also an online series for trademarks that happens on, what is that, the 24th and then the 31st, et cetera. And then I ran into this. If anybody's interested in more detail about the first-time filer program, they're going to be discussing it at essentially a, what do you want to call it, like a webcast sort of a format on the 26th. Yes?
Let's say I filed a provisional patent, but I didn't do the ultimate patent filing. I still be eligible as a first-time filer?
I don't know the answer.
I think on the slide it said that you may be eligible even if your name is on the provisional or non-provisional.
Yeah, I guess your question was you filed a provisional, but now this is a non-provisional that does not have priority to that provisional.
So I just never filed the ultimate patent application because I just wasn't on previous.
It says, no, it says clearly here, non-provisional. So you should still qualify because, assuming that this slide is correct. In the back.
I'm curious about performing patent search before filing either provisional or non-provisional patent. Like I've heard it's sort of discouraged maybe to do patent search, but yeah, I'm curious your advice.
Yeah.
What was the question?
So, okay, repeating the question, should you do search before you actually file? When I was in industry, my management discouraged me from doing any search. They just wanted me to write up the idea and fire it off to the patent committee. As an individual inventor, I've also had advice that to take a look at other work in your field to figure out how a patent application is put together. What does the disclosure look like? What sorts of things are people worried about making sure are in there? What does claim language look like? So, there's some balance here that could be case specific to you. You might want to talk to an attorney about, how deeply should you look. If you do no searching whatsoever, your application is going to come to an examiner like me. I have years of experience in searching. It's what I do. So I will go off and search because that's my job.
There was an event listed for search virtual entities. 1026,
Am I going the right? Yeah, there we go.
Yeah, 28 search.
Right here, yes. So this talk on the 26th will cover the search tool that we provide to the public, which,
That's online, right? The one on 26th, is that online?
yes, this is online,
Virtual?
virtual. Actually, if you want to, I could navigate to it, or I'll just keep answering questions for now.
I have another question.
Yes.
So, if I didn't do the search and I missed some
You've gone, this is a question of defining the boundary of the idea you're looking for. So the question was, I've made a patent application, the examiner found something and said, no, you can't have it because. What you can do now is modify the boundary of protection that you're asking for so that it is now inside of whatever it is that the examiner has found in the field. My job as an examiner is to find the best reference that's closest to what it is that you have disclosed, which should give you the benefit of saying that, okay, this is the best the examiner can find. Then I modify what I ask for so that it doesn't infringe upon that, and vice versa, and then send it back to the examiner. Now, confession time, I will say there are times that then like the second or the third time I look at something, I get an aha moment and go off and find something else. I'm sorry, but it's, something, I pick up 6 months later and my brain has, something in my subconscious has worked in the last 6 months, and I'm like, oh, wait a minute, what about this? It doesn't always happen. Yes, sir.
Yeah, I'm just getting into the search part, but I hadn't even used that. I was using Code Scraping and other tools, so I knew once they download a bunch of books and screen it. What bugs the hell out of me is what happened in Berkeley. I also watch the law journals. This is not my field, but Jennifer Blatna and Emmanuel Chapatniak got the Snowball Prize for Cas 19 in engineering, but they lost the patent to Harvard. Because
Is this a CRISPR patent?
yeah,
Okay.
they lost the patent because it was whereas they had a naked discovery, Harvard had actually used it for biological cells, and because of that reason, they got the patent. And I'm like, damn, you can't even get called an inventor. That sucks.
I'm somewhat aware of the CRISPR patent issue, but not to be able to defend one side versus the other.
All right, cool. But I mean, Eureka doesn't work anymore.
No, I think Eureka works, but when you have multiple huge research teams going after the same target at the same time, then you have this definite question of who got the Eureka first. Who actually wrote it down first?
This brings me back to Alexander Graham Bell. I understand he got the patent, but he got there 5 minutes before his competition, and what he patented, if you put it together, it doesn't work. And then he put the second patent, it works, but looked a hell of a lot like what his competition had.
I'm not going to debate the Bell patent. I will say the patent law has changed considerably since the time of Alexander Graham Bell.
Okay, and there's this, I don't know if they still do it. Berkeley has a patent law in 59 minutes, although it takes actually 110. But there's a lecture that happens there every year where they do have a patent law and what it is and how it should be changed.
Oh, so they're like, this is our suggestions for how to improve patent law in only 59 minutes?
Well, we
I
actually
mean,
hour 15.
I've sat through multiple hour discussions about whether AI should be patentable or not. How do you get this down to 59 minutes? I'll send me that link, please.
Okay.
Yes, sir.
Do you see any advantages of patenting software? Talking to multiple people who just don't bother. Some lawyers, law firms say you should. We've seen even recent cases like Clubhouse is a really good example. It did really well. And then other companies just pretty much copied and just like changed something slightly and it's legitimate.
Patentability of software is a very, very tricky area. Unfortunately for me, I spend a lot of my time there because I work on the algorithms that work on sensor data. So it's all software, grounded in some sort of reality, but at the end of the day, it is software. I would say that there is definite benefit to getting a patent around software. The thing that you have to figure out is how do you determine if someone is infringing your idea? going back to my, get off of my lawn example, it's, if I've got a piece of software and you've got a piece of software, how do I say that he's using my idea in there? And unfortunately, I don't have a particularly great suggestion about how to do that.
Yeah, but I think you got a lawsuit going on now, I guess, Elasticsearch versus AWS, because they took their stuff and basically made a minor change to it and saying, okay, now we're selling it. And of course, Microsoft never got the TCP/IP stack to work until they stole OpenBSD stack, and then they're, okay, everything works now. So like, yeah, all right, it's a lawsuit.
Yep.
Would you be able to speak for 2 minutes about your AI and ChatGPT and the hours of
Oh, the hours of discussion of the academics about whether or not AI should be patentable. Well, the current state, there's so many questions about AI. Okay, so let me go with the simple one. The courts have so far ruled pretty firmly that you can't say that an AI has invented something. The legal system of the United States says it needs to be a natural person that does something. So you could be a natural person, trains an AI, and then uses the AI to do something, and you write a patent on that. But I can't say that ChatGPT created this thing because there's no natural person behind it all. Now the next question is, if you've got an AI, how did it get to that state? Can you, in your written description, describe to me how you trained the AI to get to the point that it's doing this particular unique and novel thing? Do you need to disclose your entire set of training data in order to get a patent approved? We haven't figured that one out yet. And then, there's also a lot of articles I've seen gone by recently about, did you actually have the rights to use the intellectual property of other people in creating your training set in the first place? I'm just scratching the surface here. As I said, I've listened to hours of this discussion.
And then in your day-to-day job, do you see any impact from this AI tools like ChatGPT when inventors are fighting patents?
I have seen a demonstration of a guy that was using, it wasn't ChatGPT, but it was related, large language model thing to create patent applications. And I scratched my head as to figuring out, how is this actually going to fully disclose the inventive concept? I didn't get to see the text that this thing actually generated. I think it's also well known that large language models have a tendency to hallucinate. So do you want hallucinations in the middle of your patent application? And then there was one other.
AI-related issues with patentability are actually being discussed within our agency and requested for comment from the public.
Yes.
We actually have a whole initiative right now on artificial intelligence and emerging technologies partnership meetings where we're trying to get public comment on what they believe on patentability on AI concepts.
And are these
So
meetings
it's
open to the public? Can I come to those meetings?
Yeah, they're listed on our events webpage. So if you care to look at some of the past programs that have been offered, some of the other discussions, take a look. But ultimately, most of this is going to be decided either by the courts or by legislation enacted by Congress.
So you have to write the recommendation. Someone has to write the recommendation.
So we're gathering feedback, but we don't have a stance.
Yeah. Let's see. I'm looking right now to see.
If you go to the main
Main
webpage,
page. Yes.
it might be highlighted as AIET.
Oh, I'm looking at the wrong thing.
Scroll down.
Not right now.
Scroll down. Oh, it's not. Sometimes it's highlighted right there as one of those boxes. But if you want to just do a search on AI
Okay. Okay, there we go. Oh, yeah, there's the cards up here if anybody wants them. No, that's a slide deck. I'm sorry, Ken, I'm not finding it. So, but I did have the IP identifier a moment ago. There. This is the thing I was asking before, that just asks a few simple questions and then spits out patent, trademark, trade secret, copyright as avenues to pursue.
Stretch at this point, but I believe there was this one humanoid granted, I believe it was an honorary citizenship. So if that AI, well, the humanoid were to apply for an AI-based application, now that robot is not a U.S. resident. I believe it was granted by Saudi Arabia or one of the Middle Eastern countries. Then would that robot be able to apply?
My end, it's still, yeah, under U.S. law, that's not a natural person, so would not be recognized as capable of filing a patent application in the United States. So that humanoid may be able to create intellectual property that's valid within Saudi Arabia, if that was the correct country. But then whoever is controlling it would be challenged to leverage that into other countries around the globe.
Just to say, like, the chimpanzees and orangutans do not have a right of freedom. So the right of freedom is given only to the human beings.
Okay. Yes?
There's a weird patent. If you've got a subscription to the Wall Street Journal, it was about 35 years ago, someone filed a patent for cloning humans without heads so they could put clothes on as mannequins. I don't know if they ever got it, but it's like that fits along the line of, well,
I believe that something like that would not be eligible subject matter for a patent, according to Title 35, Section 101. Did you find it? Okay, well, okay, so other, I'm tired. I don't know if there's still people online or not. I kind of just want to get off the stage. Any other questions? Yes.
When does the provisional or non-provisional become searchable publicly?
Provisionals are not publicly searchable. Non-provisionals become searchable 18 months after original filing. Unless. So it's 18 months after original filing, but you can request that it not be published until the patent is granted. It's a check mark on the paperwork that you send in. So if you think that's really important, you can use that leverage.
So it's 18 months after the provisional is filed?
18 months after the non-provisional is filed.
Is there any way to file any of it under a black box? To file, he said that with patent you have to disclose procedure, essentially.
Yes.
Is there any way to protect any of that 7 of it? From public search?
The public policy issue here is that you're exchanging your idea for the ability to keep other people from using your idea for 20 years. A black box does not allow me to take a look at it, at what you did, and say, oh, that's interesting, that gives me another idea. So as far as public policy goes, no.
Along those lines, I think that if you went to a patent attorney and they said that if you reveal this, you're going to have a bunch of other companies trying to replicate your patent, then the best thing to do would be not to file a patent, right? Yeah.
Right, and that might be to your advantage.
It might be to your advantage not to file if it's that secret.
What about the idea of filing provisional and every year renewing it, keep renewing it? So technically you will have, no, well, you will have it.
Well,
And if you decide,
That's a risky way to go.
that's very risky because somebody comes in and actually then files a non-provisional.
and you'll be monitoring it, and you'll see somebody's after it went on provisional, it takes months, and worst case, they ask us not to publish, and now you don't know until the patent shows up on the database. I remember, when I was in industry, I could always tell when one of my patents had been granted, because then I started getting mails from the guys that said, we can put your patent on a coffee cup.
What's that again?
There's these companies that they like, they'll put your patent
On a coffee
on a coffee cup,
Oh,
or
okay,
a wall magnet, or yeah, those are companies
Yeah.
that, they're like, I would always hear from them before I heard from the company.
So
Yeah.
the provisional is never searchable, even if you don't do anything with it.
Yeah, it's visible to the examiner, but it's not visible to the public.
Unless it becomes
When
so.
the patent's granted, all of the correspondence between the examiner and the inventor becomes part of the public record. Like, I think the provisional may be visible to that. When we actually say here's the patent, that everything becomes part of the public record. So it's public record.
Okay, my nonsense question. For amendment protection, can I just put a trademark or a trade secret on my backpack and have cop not search my backpack? Cop cannot search.
That is so far outside of my scope of expertise, I couldn't even begin to answer.
Yeah, okay, it's complete nonsense, I guess.
Okay.
I have a patent on that zipper.
Yeah.
No, I think he's saying that he wants to put his idea inside of a non-searchable backpack.
So
But again, it's like, but if your idea is inside something that's not searchable, how do you prevent somebody from infringing on your idea? You can't prove it's right.
So I'm just trying to safeguard my backpack from not being searched by. Because if I can just put a tag, then I have a trade secret and I have typewritten secret.
Oh, I think you misunderstand the trade secret. It's not, the trade secret doesn't protect your secret. It's just that if it does get out, then you have steps you can take legal action.
There
It
is
won't
no,
protect it.
the United States government does not register or enforce trade secrets. It's entirely on you to keep your secret secret. Lawyers don't. And non-disclosure agreements and private contracts.
So Coca-Cola, their law enforcement will look inside their quote area where they're
Yeah,
There will be crime committed inside cops' rooms.
right. They will not search the area.
There will. If there is crime committed,
You're conflating totally different aspects of the law. If a crime has been committed, I believe that the police have every legal authority to enter the premises and do their investigation.
embassies are only exception when it's non-US territory, like embassy of Israel.
Well, the Israeli embassy is essentially outside of the
So you can declare your backpack to be embassy.
wherever the local Coca-Cola plant is on U.S. property.
Like philosophical bit. So like, why isn't intellectual property theft treated from a law enforcement standpoint, criminal standpoint, as physical property theft? Like, you don't see people like throw them in jail for,
Physical property, you deprive somebody's home.
but that's what underlies the intellectual property theft.
It's unlimited patents, right? So intellectual, you can make billions of
Well, sure,
patents.
but
So your
then
backpack-
conceptually you're depriving somebody of a resource.
Monetizing.
You're depriving the right to
Yes.
revenue they could.
If anything, it's more valuable a lot of times than something that's,
So why is not penalty for
Yeah,
infringing?
I don't believe that intellectual property is covered by the criminal code.
Copyright violation. It's a matter of.
Seems like it's more
conceptually, there is no one constitutes, but it's just interesting how they're reviewers.
So my take on it is that
Because for me, that if we want to foster innovation, then the better we're able to protect property rights, then that
but you're
increases
putting
competition.
restrictions. America is all about not putting restrictions. If you put in restrictions like nobody can do anything, it's all mine, then other people can do it. It's supposed to be open until it's closed. And closed, you put the patents, you put the wires.
Well, my thing is, the more people are protected, and at least giving credit, then that will open up more.
You can go to Wisconsin.
Share it, share it. Well, but then, that's not that's a criminal offense. Right, but then that's at the end of the day.
Well, I've already kind of written it, so, I mean, I've written it to Grant, so I've already disclosed as much as I know, like, how I think it should be functioning. But there's a lot of hypotheses.
But yeah, I'm just saying that, yeah.
There are various hypotheses of how this could work, whether or not, which one would, I don't know.
I don't think this contradiction has been addressed. Maybe just for instance, just having more power. Yeah, maybe that's not being practical. But I think intellectually there's
Well, I know how to do it, but I don't know the, I know that, I know how essentially, I know essentially what the project is.
That's a part of it. Paraphrase. You know what the instance of your remark, you know what files is for remark, but you're unsure about data.
Like the mechanism, like scientifically, how I can try.
Yeah, and you have some kind of proof, like, one of the things that,
Well, I think we're talking about
Is that the other part of the space question, the Bitcoin trails,
yeah, the journal dates everything.
and
I just want to grab a couple minutes. When I had this idea, when I had this,
push enough mechanics that help somebody else replicate the work. So you will mention the presentation that when you file your patent, somebody will take your patent, modify it, and modify it. Like, so your idea is this viable, but it doesn't work. Yeah, you take your share, they innovate, they make more money, everybody. You're welcome.
that's kind of the reason that there's knowledge hiding.
Well, so yeah. No, so here's what I'm fine with you. Okay, so here's the thing. I'm fine with you building on top of what I created. But with that, I need the credit for the initial building block. Yeah, but then taking it and then modifying something and then saying that this is all mine. That's different.
I mean, I'm struggling with, like, I'm actually struggling with this right now. Yeah, I'm at Fortnite technology, and I'm literally, I didn't file an application today. Luckily, they kind of